Good morning, Counsel.
Good morning, Your Honor. Attorney James Medley for the defendant, Pytou Heang. I'd like to start off addressing the first issue in my brief, which basically has three parts, so it concerns the expert testimony that was presented in this case. Trial counsel filed a motion in limine to exclude the ballistic evidence and the gunshot residue evidence. The judge denied the motion prior to the trial. And concerning the first part is concerning Trooper Lumbar's testimony concerning ballistic comparison. The judge ruled at the motion in limine that he couldn't say that the markings on any bullets or cartridge casings were unique at all, and he couldn't say that he could exclude all other 9mm weapons as having been fired those particular bullets. Trooper Lumbar testified that there were 3 bullets and 3 cartridge casings found at the scene of the crime. He compared those bullets and cartridge casings to ones that he test fired with the 9mm weapon that was found on the 3rd floor of 17 Moore Street. And he compared those using a comparison microscope and found that each had 6 lands and grooves with a right twist. However, he didn't present any photographs, any charts, or anything that would allow the jury to compare what he indicated his opinion was of the comparison markings. Now, 4 times during his direct testimony, he basically said that those bullets that were found at the scene of the crime were fired from that 9mm weapon that was found in the
direct, or was that on redirect?
That was on direct. 4 times.
The prosecutor presents it that there was a, and I have to confess I haven't read the actual testimony, but that there was an order to these things, that there was the testimony and it was on direct about opinion and followed by, I can't say that this is, it could be from, it's not that it could only be from this gun, and that the more definitive representations came on redirect after the issue had been opened and crossed. Is that you don't agree with that?
Well, there was some definitely ambiguous testimony. As I said, on direct, he said 4 times, that's the gun that fired those bullets, which he wasn't supposed to be saying, according to how the judge ruled. On cross-exam, again, he said...
But did he also say, I'm not saying, in substance,
at some point,
this could have been from some other 9mm gun?
At some point, he did say, I can't exclude other 9mm weapons. But my point is that if you take it all together, 7 times, he basically said, that's the weapon that fired those bullets. 4 times on direct or 2 times on cross, and then right at the end, when trial counsel objected, he said it's a practical impossibility that another weapon could have fired those bullets. Now, stating that that weapon fired those bullets is basically excluding all other weapons, which the judge had indicated on the motion in limine that he couldn't do. Now, the National Research Council report that I included, well, the trial counsel included with his motion in limine, the report on ballistic imaging, which came out in 2008, was commissioned by the Department of Justice, state that the science is just not that precise to allow a person, an expert, to say that's the weapon that fired those bullets, and it's a subjective opinion. And the examiner can't say, shouldn't be able to say, that he can exclude all other weapons, which is what happened in this case.
Well, but, can't you also understand that as, it's my opinion that that's the gun, but as I've already told you, I can't exclude all other weapons. Or is it a matter of emphasis?
Well, as I said, I think the testimony was definitely ambiguous, but for the most part, I said 7 times he basically said that's the gun that fired those bullets, which the judge indicated he wasn't going to be able to say.
But did he use precisely those words, or did he say, it's my opinion? I know you're saying that it's one and the same thing, but I'm trying to figure out, what did he say exactly?
He said, I recall specifically on cross, he said, that was the weapon, sir. That's the weapon that fired the bullets.
Not that it was his opinion that it was the weapon.
I don't think he said it was his opinion.
That was on cross that he said that?
I specifically remember on cross, on direct, I believe he said, that weapon fired those bullets.
How did the prosecutor deal with it in closing argument?
I don't know if I can recall exactly what the prosecutor said in closing argument at this particular time.
Did the judge, I know the judge ruled before trial that he couldn't say this is a unique, it's only this gun and no other gun. and seemed to emphasize that it had to be presented as opinion testimony. Did he give any, in his instruction on expert testimony, was there any specific reference to this? That is, to the ballistics testimony?
No, I believe that the instruction on expert testimony, I believe, was pretty much a general instruction.
So he didn't say at any point to the jury, the judge, didn't say at any point to the jury, this witness can't say, all he can do is offer you his opinion on this. He didn't, in other words, he didn't tell the jury the sort of substance of his ruling.
I don't believe so, no.
So,
Now,
go ahead.
So what is the rule we should put in place with regard to ballistics testimony? I mean, let's assume that this expert really did believe that he was certain that it was the gun, because he believes that the science is such that he's unable to make that. What should we say are the limits?
well, I think the only guidance we have right now is some of the federal cases that I've cited in my brief, the Commonwealth also cited, and the judge even cited in his decision on the motion of limine, that seem to indicate that the acceptable opinion is either more, quote, more likely than not, or it's, quote, a reasonable degree of ballistic certainty. That seems to be where the federal courts at least have come down on this particular issue.
And would it have mattered to you if the judge had said, no, you can't say that, but you can say that to a reasonable degree of ballistic certainty, that's this gun fired those bullets?
I think it's more beneficial to the defendant to say that than that's the gun. That's certainly
Didn't the
gun.
judge, I know there's in your view anyway, and you may well be right, there's a discrepancy between what the judge ruled and what the witness said, but didn't the judge rule that the witness could only say, could offer an opinion to a reasonable degree of scientific certainty, or did he say ballistic certainty? And is there a difference in your mind between those two?
I'm not clear on what the question is.
Well, I thought I remember, and maybe incorrectly, that what the judge ruled was he could offer an opinion to a reasonable degree of scientific certainty that these bullets came from that gun. You just had an exchange with Justice Gantz about ballistic certainty, and so one question I had, assuming that the judge ruled that, is there a difference in your mind between scientific certainty and ballistic certainty?
I don't really think so. No,
Okay.
I don't believe that's the case.
And so if the judge ruled that, but you're saying he might have ruled that, but that isn't what happened.
That isn't what happened, right.
Yeah, okay.
And I think part of the problem here...
I don't mean to beat this to death, but is ballistics considered a science? Do you know?
Well, I guess it's considered a science since it's discussed in that
context.
in that report, and then in the follow-up
Okay.
report from the NRC.
Now you mentioned that there were no photographs used by this expert in his testimony. Was the jury able to evaluate the testimony apart from his opinion? Were there charts? Was there data given? I mean, how was the jury able to examine whether or not the similarity is such that they credit it?
As far as I can see, there were no charts or any measurements or anything taken, any photographs shown to the jury at all, which is getting into the second part of my argument on this issue, is that there should have been a Daubert landing and hearing, which I think would have cleared up some of these things prior to the trial, because at the trial, you'll see that the judge basically takes over the questioning of Trooper Lombard, because basically assisting the assistant district attorney in proving the case. And I think a lot of the reason for that is because they didn't have the Daubert landing and hearing, so it wasn't really, some of these things weren't brought out ahead of time. The fact that there's no photos, charts, or measurements, perhaps the judge, if there was a hearing, perhaps the judge would have ruled that Trooper Lombard couldn't testify at all, based on the fact that there were no measurements, et cetera, et cetera. During the trial, the Trooper Lombard mentioned some terminology, didn't explain what they were, and again, testimony is very ambiguous as to what his opinion actually was. And I think some of that could have been clarified if they had a Daubert landing and hearing prior to the trial, which I think is the usual way these situations are conducted.
Didn't he testify pretty specifically about what it is that he did? And didn't those include examining it under a microscope? And but you're saying there was no actual measurements? I mean, what,
There were no, he didn't testify to any measurements or, like I said, there were no photographs presented to the jury so that they could compare what he had compared in the laboratory.
Counsel, even assuming everything you say is correct, wasn't the evidence in this case overwhelming?
I wouldn't say it was overwhelming.
Well-
There was 4 days of jury deliberation, so I would say that weighs against the evidence being overwhelming.
Well, almost immediately after the murders, the police arrested. They found the evidence. They found the assailants. They found the black gloves. They found the do-rags. They found the jackets. They found the gun, right?
That's right. Although my client was not arrested immediately, if you recall, he was released right after.
Well, they identified
and then was
him.
released again after he gave his statement. So it wasn't, nobody actually identified him as being, I mean, I understand what you're saying, but I don't think the case was an open and shut case for the Commonwealth. There was no real identification of him as being at the scene of the crime. The third part of this argument is on the gunshot residue evidence, the argument being that this evidence really doesn't tend to prove anything. Counsel moved to strike the evidence after the Commonwealth's expert, Alana Foster, testified. The motion to strike was denied. During the motion limited, the judge admitted that this opinion evidence is very generalized, but because it's generalized, it's not really going to prejudice the defendant, so he's going to allow it. Now,
why is it irrelevant that there was residue which either came from the person firing the gun or being next to somebody who fired the gun or having rubbed against a person who did? Under these circumstances, doesn't that narrow the set of persons involved? Isn't that more relevant than if there was no indication that there was gunshot residue?
well, I just think the opinion is so generalized, as you said, that they can't determine either the person fired something, was in contact with somebody who fired a gun, or was near somebody who fired a gun, when it was put on the... Excuse me. I've had a cold the last 2 weeks. So.
Okay, but it was a joint venture, so even if he didn't fire the gun, the fact that he was next to somebody who had just fired a gun under these circumstances would be probative, would it not?
Well, unfortunately, nobody can say when this alleged gunshot residue was put on these items, so I would just argue that it really doesn't have a tendency to prove anything, and it came out during the motion limiting hearing that the FBI, Boston Police Department, they're not even using gunshot residue anymore, so I question the usefulness of that kind of evidence at this point. The second issue in my brief concerns my client's recorded interview with the police shortly after the shooting. Thank you. In which it contained numerous denials that he committed the crime and asked for a lawyer. And there was no objection by counsel to this recording being introduced into evidence and the jury hearing it. Now, there were 6 denials during the course of the interview.
Isn't that great, though? Doesn't have to testify now. The denials are out there.
Well, I don't think it's necessarily great.
I mean, lots of times defense lawyers would love to get their client's statement in because it's a denial and it can't come in because the prosecutor didn't introduce it. Well, here the prosecutor did.
he's speaking against his own case.
Yeah.
I really don't think it was beneficial to the defendant, no, because the jury got to hear all these accusations of the fact that you're not telling us the truth, or why don't you tell us the truth? Why don't you help yourself out? That kind of, those kinds of accusations. And my client saying, no, I didn't see anything, I didn't do anything. I don't think that benefits the defendant at all, really. And to compound the problem, the ADA mentions it 3 times in her closing about my client. He denied that he denied he was involved in the crime, denied he committed the crime. There are 2 cases that were cited by the Commonwealth in their brief as being pending before this court at the time that the Commonwealth filed their brief. That was Commonwealth versus Womack, decided in July, 457 Mass 268. Commonwealth versus Barbosa, September, decided last month, 457 Mass 773, which are on point somewhat, although those cases were not recorded interviews. There was just testimony by a police officer as to his conversation with the defendant.
Right, but isn't the gist of both of them that it's okay to put in a denial where there is probative value for the prosecution from the denial, and it's not okay when the only purpose for offering of the denial is to get in the interrogating officer's theory of the crime?
Right, I
Isn't
mean,
that sort of the essence of those two cases?
yeah, this court obviously didn't provide relief for the defendant in those cases. But they did find that it is error to introduce, especially, the denials and the accusations shouldn't come into evidence. That was error. This court did find error. But you're right. This court found that as long as the denials were consistent with the defense, which really should be pretty much automatic if you're going to trial, you're denying you committed the crime. The thing I actually have more of a problem with even than the denials and the accusations are my clients at the end of the interview where he pleads the fifth and then asks for a lawyer. I think that's more prejudicial to my client than even the accusations and the denials, because I think that the average juror would think, well, if somebody is, quote, pleading the fifth and asking for a lawyer, that they probably have something to hide.
Well, the judge, I'm not sure, I take it that counsel agreed to have that in after discussion with the defendant, and that the judge said he could see a tactical or strategic reason why that should be so. Is that?
That's correct.
And you're just saying you can't figure out what the possible tactical.
I would argue that it's an unreasonable strategic decision by trial counsel to let that, certainly the end of the interview, come into evidence.
But again, I've not read the record, but if when I do, is it fair to say that we'll see the judge saying to the defense lawyer, are you sure you want this in? Because I would order it out if you tell me to, and the defense lawyer say, no, I want it in.
Yes,
and the judge agreeing that there was a reason to let it in, correct?
That's correct.
So what do we do? I mean, if the judge had said, no, I'm going to knock it out, then you'd be here saying, let the defense attorney try his case. He made a reasonable tactical choice and was denied that opportunity by the judge.
Well, as I said, I think it was an unreasonable tactical decision on the part of trial counsel to let that portion of the interview come in.
Was there any discussion about what the tactic was? Sorry, in other words, what the strategic benefit of this was?
I think the only discussion would have been maybe about the denials. I believe, that it allowed the client to get in some denials without testifying.
But this is specifically about the I would
Right.
like a lawyer. I
don't-
plead the fifth.
I don't
Wasn't it?
recall there being much discussion on the record about that part of it. I think there was some discussion about the denials or sidebar discussion that trial counsel felt that getting in the denials would be beneficial. His client wouldn't have to testify.
Because I thought that what the judge said he would cut out was just that ending part. That is, I want a lawyer. I plead or take the fifth. Is that not right?
I don't recall any specific discussion about the latter part of the interview at the end. The third issue in my brief concerned a letter that a juror wrote to the judge 6 days after the verdict came in, indicating she was intimidated into voting for conviction. Counsel filed a motion for reconsideration after the judge's decision, which preserved the issue. I'm aware that the case law talks about extraneous influences, and this letter is really more about intimidation or coercion by the other jurors. The letter does indicate that some other jurors were taken outside the jury, which may indicate some extraneous influence there. And there are some cases that I cited in my brief which discuss jury coercion and intimidation, and that the defendant is entitled to a uncoerced verdict of a jury. The other problem that I have with this, or the main problem I have with this, is that the judge didn't inform counsel about his decision prior to making his decision. In other words, he never sent a letter to counsel, just made his decision and then informed counsel about it. Now, in a case decided shortly after I filed my brief, Commonwealth versus Semito, 456 Mass 1, it was decided in 2010. The judge did share the letter. It's a very similar letter to my case. The judge did share the letter with counsel before making the decision, but he didn't do it in
I'm sorry, is it your position that the judge should have held an evidentiary hearing to take evidence as to that issue based on the letter?
I think there was enough there concerning intimidation and coercion that the judge could have held a voir dire hearing with that juror.
Because I think in Sumedo, the judge had an argument by counsel, but he didn't have an evidentiary hearing, if I recall correctly.
That's right. He didn't hold the evidentiary hearing. He found that it was no extraneous influence and decided not to hold a hearing. But I think if you read the letter in Sumedo and you read the letter in this case, I think you're going to see a little bit of a difference between, I think in the letter in this case, I think there's more intimidation and coercion than in the Sumedo case. If you really look close at the two letters.
Thank you, counsel.
Thank you.
Good morning. Catherine Semmel, appearing on behalf of the Commonwealth. I'd like to clarify at the outset the judge's ruling about the ballistics testimony, because we talk a lot in our briefs, both of us, about reasonable degree of scientific certainty, because that's the way it's been discussed in a lot of the case law. The judge's ruling was that there needed to be, that the Commonwealth could elicit the trooper's opinion that the projectiles in question were fired from this firearm, which is what happened on direct, but then needed to follow it up with a question which was essentially, well, or exactly, the prosecutor asked, as a matter of science, can you exclude every other 9mm gun with 6 lands and grooves with a right-hand twist as having fired these projectiles? So we weren't using the terminology that is in a lot of those cases, and this is specifically what the judge told her to ask as the follow-up question. But I think it's essentially the same thing.
The defendant says that may be the judge's instruction, and maybe once the Trooper Lombard did that, but I think he said 4 times indirect, he said that's the gun from which these bullets were fired. I mean, sort of, what I take that to be is, and as I said, I'm sorry, I haven't read it, but as an assertion, not an opinion, an assertion of fact, and also that it's that it's the only gun that could have done
I think that there's a little bit of compiling going on, because in direct, I think the court will see that when it was asked by the prosecutor, it was framed in terms of his opinion. Is it your opinion that these projectiles were fired from this gun? But what happened on cross is different, because at that point the defense was asking questions about, well, can you exclude any other AB-10? And the officer was saying, did say, I don't have the exact quote, but it was this AB-10. And he didn't express it in terms of an opinion. It wasn't asked in terms of an opinion. But I think that the court can readily conclude, in view of what he testified to on direct, that he was reiterating his opinion. And I think the fact that even though it was a defense question, the fact that he didn't ask for a sidebar, didn't ask the judge to re-instruct the trooper, that it was readily understood by everyone there that he was reasserting his opinion that he had issued on direct examination.
Have you do you know the Gambora case?
Yes, Your Honor, the fingerprint case.
The fingerprint case, that's right, which has a similar issue.
Correct.
And there's some discussion and a concurring opinion by Justice Spina about the need for being opinion. Do you think, and I haven't...
The need for what? I'm sorry?
The importance of having this evidence come in, if it comes in, as opinion as opposed to fact.
Yes.
And so I guess my question is, not having read the record, do you think that, sort of keeping that in mind, is that what happened here in your view?
I do, and I think if you just look at the cross, then I think the defendant has a very good argument that that's not what happened. The jurors would understand that he's saying, oh, no, definitely, absolutely, that's the gun. But you can't just isolate that when the officer trooper has already stated the limits of his opinion. There's 2 clear parts here. There's his opinion, and there's the acknowledged limits of it. And those are set forth in direct, and they have to carry over into the rest of the case.
And is the opinion consistent with the limitation? That's what I guess I'm confused with. He says, it's my opinion that this is the gun, but I can't say that there are not others for which it may be the gun. How is that a consistent opinion?
Because, I think it's the same as saying, to a reasonable degree of scientific certainty. It's my opinion that this is the gun. I cannot, as a matter of science, exclude every other gun, but based on my experience and the comparisons I've made, it's my opinion that this is the gun. And I don't see them as inconsistent. I see them as an opinion and then the acknowledged limitations on that opinion.
But I forget the name of the case, with regard to DNA, we required some degree of statistical reference.
I think that would be Matei, because I remember it very well, because I
You remember
argued it, Your Honor.
cases better than I do. I remember holdings, not cases. But here, I mean, it's not clear from that testimony whether or not we're in the DNA world where you can say, I can't exclude it. There could be one in quadrillion. There could be, in a quadrillion people, there could be a second, or whether he's saying there is, I can't exclude it being any other gun that was in that manufacturing lot made that day. Could be a different magnitude in terms of what the numbers are.
It's true. I mean, but this is not a science where there's quantification. In DNA, there's quantification.
Yet.
And not yet. Although I won't get into that because I'm liberal arts, not science. But I'm not sure you could ever quantify this type of science.
I think one of the points of the NAS study is that there needs to be more research done so that there is some basis of having a statistical comparison. I think.
That's true, and that's a goal, and it's a difficult science to have that with. But I think part of the problem in Matei is you have mixed samples and you have confusion because jurors hear these types of statistics. So suddenly when you are introducing could be included as in mixed samples, then jurors may misinterpret what that means unless you tell them.
I guess that's the question here. If you take it from the point of view of what the jury heard and understood, is there a comparable risk of confusion here?
Well, two things. One, no. I think the jury, first of all, heard a lot about the methodology that the trooper used, about how he test fires, that he then compares the test fires to see that they're similar, because he says if they're not similar, then he can't possibly compare them. He takes the best one, then he best markings, compares that to the actual bullets or casings from the scene. He makes a determination that there are enough similarities of individual characteristics that he can determine, and again, this isn't quantified, but it isn't quantified, based on his experience that they were fired by the same firearm. He then is reviewed by a senior ballistician. So jurors, this isn't a case where you have photographs where they can look at it and kind of replicate or check the expert's testing. But no,
And I guess that's a question.
does it need to be?
Should that be required? Should we enable the jury in these circumstances to be able to evaluate for themselves the credibility and reliability by requiring the ballistics person to have photographs? In the cases that I tried, the better ballistics officers made photographs and showed the jury, had them side by side, and said, look, this is the test and this is the actual.
And I think in this case, there was some testimony, and I would just like to clarify one thing about the record, because on cross, as was to his benefit, the defendant brought out what photographs the trooper did take. This isn't the case that there were no photographs. What the trooper testified to is we take photographs of the test fires that show the areas that we rely upon. They don't take other photographs that you can then compare them to, because he said the resolution they get from the printer on a one-dimensional picture is not enough. You can't make meaningful comparisons with the photographs. Maybe other labs have better equipment. Certainly in Meeks, the Suffolk case that had a Daubert Lanigan, it seemed like the Boston Police Department have some capability of doing this, at least to the degree that they think is good enough. The trooper here said that they didn't. It seems to me that it's really, I don't think this is a place where the court wants to be making black letter law, but what has to go in front of the jury. They have an opinion, they have a methodology, they can give that what weight they desire, and the defendant can produce his own witness. This defendant had funding provided, for an expert ballistician, as discussed at various points in the trial. The court pointed out at one point, that in sidebar, that they could have gotten the testing they wanted. They could have independently tested it. This is not an instance, maybe like in DNA, where the evidence is used up or you can't retest it. It seems to me that this is an area for cross-examination, and the deposition of a trial setting rather than setting black letter law, which I would just note is not necessarily beneficial to the defendant. I mean, you'll note that the defendant here never challenged the trooper's failure to produce any kind of documents. And had he, we might have tracked down a lab somewhere who could produce what we needed, which certainly would not have benefited the defendant in this case. Instead, he got to cross-examine him about the lack of them. So I don't think it's a threshold requirement that you have this kind of documentation for the jurors can check it. I mean, this is expert testimony, and jurors are required in lots of instances to assess experts who can't replicate their tests for them. You know, in medical situations, you know, you can't replicate what was done during an autopsy. There may be photographs, but it's not the same thing.
But the difference is that in fingerprints and ballistics, in contrast to an autopsy, what they're doing is saying, I've looked at the known, I've looked at the evidence from the scene, and they're the same. So in both of them, they're saying they're the same.
Well,
and that is something which a jury can evaluate whether they appear to be the same.
Yeah, I think that, you know, it's not an exact science, and you're really not saying they're the same. You know, I think that, you know, I think there was testimony, if not in this case, I've read it in other cases where the experts had said they're never going to be exactly the same, and you have to make a qualitative assessment, not necessarily based on the quantity of the markings that are similar, but the appearance of them. And I think it's very difficult to replicate that in a meaningful way for jurors. And I don't think in this case that jurors were left with nothing to consider. And if they did, then they could, I mean, if they could disregard our evidence, they could consider it as to weight, certainly. But I don't think you want to set a black letter law about what we have to put in when we have an expert who testifies, this is what he did, and this is what he does, and here's how he did it, and this was his conclusion.
Well, should we require a Lanigan hearing and have at least go out and buy 10 guns that were made in sequence and then fire bullets from each of those 10 guns and then fire actually 10 bullets from each gun to see, A, how the rifling changes as from bullet to bullet fired from the same gun, and then B, look to see whether and how the rifling changes in the manufacturing of guns made in sequence. I mean, why can't that be determined fairly easily?
Well, I think, you know, I'm trying to think back to Meeks, to the Robert Lanigan hearing that was held, and my recollection is the experts in that case testified that they had done similar things in order to test their hypotheses. But does it need? I'm not sure if I understand the court's point that it needs to be done every time.
No,
or
probably just. Well,
just
I don't
once?
know if it needs to be
It
done
seems-
every time, but we said at least in the DNA context, if as to the same process, one hearing is, at least it's been affirmed on appeal, would be good enough.
I mean, I do think, I'm not quite sure how to answer it, because obviously, you know, that is helpful, and obviously, you know, the troopers here testify that they do proficiency testing where they, you know, they evaluate test fires and their conclusions are checked. I mean, I feel like this was, I feel like there's really not a question about the science here. I mean, all of the dialogue that's been going on about this is not about the science or the idea that there are, in fact, you know, unique markings made as part of the manufacturing process that are in turn imparted to the projectiles and casing. I mean, the question is just, you know, how certain you can be and how you express that opinion. And I'm not sure that one really informs the other. I don't think there's a question that you can in fact determine. Determine that to a reasonable degree of scientific certainty, at least, that they were fired by the same gun.
Yeah, I mean, one of the interesting things about DNA is that I think no matter how many times you take a sample from a human being, you will arguably get the same DNA. I don't know if that's true or not, but I'm assuming that that's true. I also am assuming or at least I think, that's not necessarily true with a gun. That every time you fire a bullet from a gun, it may change the force of the metal of the bullet going through the barrel will change the rifling ever so slightly every time a bullet is fired from that gun, so that 100 bullets later, the rifling that appears in the photograph may be a little bit different.
I think I agree, as a scientific principle that's probably true. And my recollection from Justice Brassard's excellent and very lengthy opinion is that one of the experts, I'm sorry if I'm wrong, but I think I recall rereading this, one of the experts testified that she had done something similar, that she had fired a very large number of shots from one gun and then tested number one against the last one and determined that she could, in fact, compare them and find that they were fired from the same gun. So I think there have been that kind of studies done and that they have upheld the validity of the science.
So essentially it goes to the weight of it, the weight of the testimony.
I think so. And certainly the defendant can produce, contrary experts to address that. That wasn't done in this case, as I don't think that there was anything to contest in this case.
Can I ask you about the closing argument? This relates to the use of the use of the defendant's statement to the police, and the prosecutor zeroed in on, you're going to hear this tape, and you're going to hear that he absolutely denied. Do you think that was appropriate?
Oh, I'm sorry. I do not recall exactly what the prosecutor said about that.
That was, I'll tell you. You're going to hear a tape where he's going to adamantly deny any involvement of that shooting. He's going to adamantly deny any knowledge of it. Remember this, he adamantly denies any involvement with the shooting with the same conviction, et cetera, et cetera. Any problem with that? I mean, if the denial itself should not have been given to the jury?
If it shouldn't have been given to the jury, except that there was no, I think that the denials were properly in evidence. I think you can presume from what occurred that the defendant thought they were beneficial to his case. They obviously are beneficial, and what this court recently discussed in the two cases that have come out describing denials is, of course, that denials are beneficial to the defendant. So just as a preliminary point, I think that, the prejudice in the denial question is usually in the question when the Commonwealth is putting forth its case. And that the denials, as long as they're consistent with the defense case, which of course they were here, are if anything, beneficial to a defendant. So starting from that point, I think the evidence properly came in. And I would just say that not everything that the defendant characterizes as denials on appeal could possibly be considered denials.
I agree with that, but this statement
but
is...
But then moving
yes.
on, so I think it was, I think the evidence is in, and I think it's fair game for the prosecutor to comment on that. And I'm not sure where she went with it, and I'm sorry I don't remember that passage exactly.
Could you refresh my recollection? Did the defendant make any narrative statements, or were they just denials? They didn't do it. Is the only thing he said?
There were lots of questions and answers. Where were you that night? Tracing his actions that night.
He did make narrative statements, didn't he?
Did he make longer narrative statements?
Yeah, I think he talked about
like,
taking the bus and...
Right. Well, they asked, they tried to retrace his steps that night. Where were you? What did you do? Who were you with? And then they got to questions, about were you in the house? Were you on the third floor? Were you on the landing? That's where the guns were. And that's when things got a little bit more heated in the discussion. So I think it was a lot of question and answers, and explaining where he was, or not explaining where he was very well that night. So yeah, I think that it's fair game to comment on something that came in that fashion.
Yeah, I guess.
And I don't think it was used in an improper way.
Let me ask you this, and it's a factual question about the record, that I thought that the discussion between the judge and the defense counsel about agreeing to allow in certain things was
The
about that.
request for counsel?
Yeah, wasn't it about that particular part?
Yes, it was about the end, and the judge said that he would exclude it if the defense wanted him to. The defense said no. Sometimes he would want to. In this case, he
What
didn't.
would be the strategic reason to allow that in?
That's a very good question. I think the reason to allow it in this case is just a couple of possibilities, and it's not discussed by the defense attorney, by the way. The prosecutor, I think, kind of theorizes in the discussion back and forth, but I think that it was part of kind of the defense plan. My guy's innocent. He had nothing to do with this. He went to Lynn. He talked to the police. Everything's fine. He's answering their questions, and it's only when they started making clear that they were trying to, pin a double murder on him that he got uncooperative and said, I'm scared. I don't want to talk to you anymore. I want to talk to an attorney. And I think there's some benefit to the defense of putting this whole narrative in so the jurors aren't wondering what happened. They have a beginning all the way to the end. There's no question that he said anything directly incriminating during this, and it's clear that he was cooperative until he got scared. And he argued it. Defense counsel mentioned it in closing, this fact.
He got scared because they were wrongly pinning on him responsibility.
And it was all this rush to judgment, this whole idea. He had the unlucky circumstance to be right in the vicinity of the murder, right after the murder happened, and that night, when they had none of this evidence that then was developed, they were focused on him.
As a matter of curiosity, why didn't the prosecutor file a motion in limine to cut off the end of that conversation, ask for permission to cut it off, all the denials and the requests for a lawyer? Or not all the denials, but at the very end.
The request for the lawyer, I'm not sure. It seems like it was discussed before that sidebar because it was because they kind of delved right into it at that sidebar.
I suppose there was going to be some explanation that the defendant asserted his right to show that the conversation, that the interview ended, or how the interview ended.
I'm not sure that we can put that in over the defendant's objection, though.
Well,
so I'm not. I don't know the answer to your question. I'm not sure how it evolved to the point where there was a discussion on the record.
okay.
Counsel will have to leave it there. Thank you very much.
Thank you very much.